Hello, good afternoon. Okay, short introduction about me, today's speaker. So my name is Annina Harju and I work as a legal counsel at Aalto University. I advise 3 departments at School of Science, so computer science, NBE, and DM. But I'm also a member of the Aalto Research Ethics Committee, and I provide legal counseling to basically all the research studies that seek statement from the committee. I myself have worked for Aalto for 3 years, and I previously worked in consulting and attorneys at law offices. So today's topic is web-based research. So let's start with aim and motivation for this webinar. So obviously, rise of social media has created huge potential research material in the web. It offers versatile material available to reflect people's views, behavior, and different kind of social topics. And when I'm talking about social media or media platforms in this webinar, I mainly mean Facebook, X, so Twitter was the previous name, Instagram, YouTube, TikTok, Reddit, LinkedIn, and more. So all these kind of social discussion platforms and social medias. And another thing that we have realized is that within research, there is this one common misunderstanding related to this web-based material. What I've heard a couple of researchers to say is that, well, if the person has published it online, of course I can use it however I like. But obviously, this is not the case. And today's aim is to help you to understand what kind of legal questions and ethical questions relate to the research project if you aim at collecting data from these social media or media platforms. So there are a couple of ways to actually collect data from the platform. The first is application programming interface. So basically this is a mean where platform voluntarily provides data in the same way as it handles the data internally. And some platforms additionally even have academic research API access, which is obviously really helpful and nice for the researchers, but not all platforms have this, just some of them. The second option is web scraping, which obviously means extracting the data from the web pages that the platforms presents to users using bots, web crawlers, or scripts. So this is more like automating data collecting from the web. And the third option is obviously the maybe least convenient one, which is manual collection. So this means downloading the videos or images or making screenshots of the websites or any other methods where you're actually capturing the content to your computer. Okay, we're going to start with legal perspectives. So there are at least 3 important legal perspectives when you consider collecting data from these platforms. The first one is contractual, and this relates to terms of service of the platform. The second one is copyrights, and the third one is data privacy, GDPR. So we will dive into all these 3 next. Okay, let's start with the contractual. So obviously, internet is global, and the creator of the content may be from any country in the world. And the large social media corporations, they're mostly based in the US, obviously TikTok in China. And therefore, the terms of use are in most cases under US laws or China. But obviously, in some cases, if the user is based in the EU, so EU resident and lives within EU, and the service is offered to the EU market, EU laws will be applied as well. this is just for you to understand that it's always actually not easy to interpret which law is applied to the case, and also regarding copyright, regarding data privacy and contractual matters, they can actually be under different laws. So that's why it's in some cases quite complex to try to interpret which law is applied to each legal question. Okay, so obviously, to begin with, the platforms are controlled by the corporations that own them. So even though the data is public, that you publish to the social media site, it's still owned and controlled by the media corporation that owns the platform, basically. And obviously, when you enter the site or you make a user account to the site, the terms of service of that platform construct a binding agreement between the user of the platform and the platform service provider. So this is the contractual relationship we're talking about. And these team terms may actually set certain limitations how the user may use the platform and data. And obviously this is binding. So as a user, you need to follow the terms. And one prohibition that is really common is that some of the terms prohibit, for example, data scraping that we discussed previously. That was the second option on the data collection from these platforms. I will not go through the terms of each platform as they actually change quite frequently. These media platforms tend to change their terms and privacy notices quite frequently. So if I tell you something today, it might not be valid tomorrow anymore. So that's why you should always check the current terms and the valid terms. So most large social media corporations are obviously based in the US. And broadly, we can say that judges in the US have ruled that information that is published to publicly viewable social media can no longer be expected to be in some way private, and that breaking these platforms' terms of service is not a crime. But you can always observe, take notes, and record information manually about the content without violating any of the terms of service of the platform. But obviously, what's the end result if you end up breaking the terms of service? Well, obviously, your account can be deactivated. So basically, your contract with the site and the platform will be terminated. And there actually has been one case in the US where the researchers were doing research on Facebook, and they were in some way using the platform in conflict with the terms of service of platform. So what Facebook ended up doing was that they terminated the researchers' Facebook account. So they closed their account so they couldn't use Facebook anymore. There's a lot of articles published online about that case as well. And it was seen quite problematic in the field of research because it was possible to argue that they are limiting the research possibilities in that way. And it's also obviously important to do research on social media and social media marketing. If I remember correct, it was somehow related to marketing and ads on Facebook. So obviously it's a big part of Facebook's business. So maybe it was a way to protect their core business in some way, and they didn't like the researchers' presence and topic of the research. So obviously it is not advised to violate platforms' terms of service in the course of doing research. So even though it's not maybe seen as a crime, but still it's not it's not recommended because you can face a lot of consequences and problems if you do so. No one wants to start a fight with these large US media corporations, and therefore it's always best to be on the safe side and follow the terms of service. Okay, next one. Let's move on to copyrights. So the second legal issue is that the platform may actually include something that is copyright protected. It could be text, it can be photos, videos, or even databases. We will come back to that later. So the main principle of the copyright is that a copyright protected work may only be used with the permission of the author and in the manner that the author has permitted. So obviously, this could be an issue if you're collecting data from the web without the consent of the creator. So let's next discuss what is even copyright protected. So we have this rule of threshold of originality in the field of copyrights. And regarding text, text can be protected by copyright if it's in some way original. So it constitutes the author's own intellectual creation. In most cases, very short texts, such as slogans or titles, are often considered unoriginal. But however, Court of Justice of the European Union has ruled that snippets of only 11 words can be potentially qualified for copyright protection. So as consequence of this, even short tweets can in some cases enjoy copyrights. So again, this would require really close case-by-case evaluation to actually find out if something like a short text is copyright protected or not. Regarding photos, usually most photographs, illustrations, and other images will be protected by copyright as artistic works. Then we'll move on to databases. So yeah, if the structure of the database cannot be seen as original creation, it may be possible to protect this content under the sui generis right. And this differs slightly from the threshold of originality because in order to obtain the protection, the creator of the database must have made a substantial investment in either obtaining the verification of or the presentation of the database content. So this investment, it can be financial, material, or human investment. So the criteria is slightly different. And again, when we can go back to the concrete cases, again, it requires case-by-case evaluation about the database in question. So it's really hard to give any rule of thumb to each and every single case because we need to look at the exact database in question. But then we come to the good news, because in European Union, there is actually research exception for data mining for scientific research purposes. And also in the US, there is fair use principle. So next, we're going to go through what these two exceptions basically mean. So under the copyright law, the research organization and cultural heritage institution, if they have a legal access to the work, these organizations may actually reproduce the content to carry out text and data mining in scientific research and also retain the copies for the purpose of scientific research. So this is really good news for any researchers if they want to use these data mining web crawlers that collect the data. So it is accepted to do that also with copyright protected material. So text, pictures, photos, things like that. And also what is an important note is that provision of this subsection shall not be derogated from contracts and agreements or prevented by technical means. So what this means that these large corporations, they shouldn't actually prohibit this with their, for example, terms of service. So this is good news for the research organizations. Okay, then what is fair use? Obviously, I'm not trained lawyer in the US, so take this with a pinch of salt. But just shortly to describe you what does fair use mean. So this is based on US law, and it is an affirmative defense that be raised in response to claims by a copyright owner that a person is infringing the copyright. So this is an argument that may permit a party to use some copyrighted work without the owner's permission for some purposes such as criticism, comment, news reporting, teaching, or research. But this is not like get out of jail card, because this cannot be applied to each and every single case. So these purposes only illustrate some options what could be considered as fair use. So they are not examples of what will always and in every case be considered as fair use. So, as we lawyers always say, it depends and it needs case-by-case evaluation in this case as well. Okay, next, we're moving to data privacy, which is our third legal question. What actually might become a surprise for some is that GDPR is also applied to data collected from the public domain. So in some cases, the researchers don't even realize that if they are collecting data from these platforms, that it is actually under GDPR. So what is even personal data? Let's begin with that. So obviously we have directly identifiable data, which people really easily understand as personal data. So for example, my name, my phone number, my email, they basically state directly my identity, or a photo of me or a video footage of my face. But then we also have pseudonymized data, which is really common, for example, in discussion platforms. If you collect data from, for example, Reddit, it might seem anonymous for you. So basically, people are often using nicknames and not their real names. So you might argue that, well, I don't know the identity of this person who has posted this comment and story. So this is fully anonymized data for you. But in that case, we need to remember that the platform may have data that enables the identification of the person. So even though the data is basically, from your perspective, anonymized, it doesn't mean that in the legal sense it's anonymous. So if the platform is able to connect the nickname and the comment to the direct identifiers, because usually when you create an account to these platforms, you obviously need to give your real identity, so your name, email, and information like that. So it's possible for the platform to identify the people, and consequently, the data is not anonymized for you either. So you can't make an estimate based on your objective view. So if it's not identifiable for you, it doesn't mean that in the legal sense, the person cannot be identified from the data. So this is really important to remember when you're collecting data online. Obviously, many people also post on social media with their direct identifiers and their own face and their full name. But in some platforms, it's more common to post information on pseudonymized form. So you really need to be careful when you estimate if you are actually collecting personal data or not. So there's no concept of this subjective anonymity, and the current interpretation is quite strict. And maybe another important thing that I'd like to point out is sharing like direct quotes, for example, from Twitter. So if you state that the anonymity will be ensured or you will not disclose any identities in the research output, but if you share direct and unedited Twitter quotes, it's really easy to find out who has made the Twitter post and who is the original writer. So this is something that you also need to be really careful with and estimate what kind of output and in what kind of form you report the final results of your research study. Okay, so GDPR is applied to this public domain data as well. But let's go through how will you ensure the compliance in practice. So obviously, every time when you process personal data, you need to have a legal basis. But in the field of research, this is usually quite easy because you can just use scientific research in the public interest as your legal basis. But then maybe a bit more tricky part is the liability to inform about processing. So in many of these studies, obviously, we don't contact each and every one of the participants about the study. You just collect the data, and the person might not be aware that their data is used for research purposes. So under GDPR, when is it possible to deviate from this principle of informing about the data processing is if it's some way basically impossible or it would involve a disproportionate effort. And additionally in GDPR, that could be the case, for example, for scientific or historical research purposes or statistical purposes. And when we make the estimate, we need to see the number of data subjects, age of the data, and any other applicable safeguards are adopted. So again, this requires case-by-case evaluation. And surely the principle of data minimization should be applied as well. So when you're collecting data from these platforms, you shouldn't collect any unnecessary data. So only data that you absolutely need for your study. And it should be also processed in a form that the identity is not revealed to the researcher either. So you should, if the data is not pseudonymized for you, you at least should pseudonymize it. Okay, all the guidance on a practical level. So case-by-case evaluation, what is collected and from which platform. But our guidance is that you should always draft a privacy notice and publish it on Aalto website. So this is basically our way aiming to transparently and openly inform the participants. It's not your responsibility to ensure that none of these people ever end up finding the privacy notice or reading it, but in this way we at least are transparent and openly give information that we do this kind of processing and this kind of research. So this relates to most of the studies, but we also have had some cases where the data is being collected from a smaller and closed group that's still in operation. So in those cases, it actually may be appropriate to publish the privacy notice in the group and inform the participants that, hey, I'm a researcher, I'm present here in this group and collecting data for the research purposes. But for example, to Reddit discussion groups which have been inactive for a long time, it's really not use to post this information, because the people who have posted to the group will never come back, and it's just unnecessary hustle, and it can be confusing for the new discussers as well, or if the whole discussion group has been closed and there are no new comments, so it's totally unnecessary in that case. Okay, there's more information about GDPR in the research. I have added instructions and link here. You will find, for example, the template for the privacy notice and further information. And we also have a published webinar about how to fill in the privacy notice and other data privacy topics as well. So if you want to learn more about that, you can find a link where you find these recorded webinars available. Okay, then next, we're going to talk about research ethics. So the legal side is now covered. So what should you take into account from the research ethics perspective? So as I already noted, in many cases in the social media study, the participants are not aware that their data is used for this academic research purposes. And there has been some debate about whether these people who are posting on social media can actually be seen as participants in the study or not, like in the research ethics sense, because we have this set of principles. For example, that the person has right to withdraw their consent from the study, and obviously consent should be asked if they want to participate or not. But obviously, in many of these studies, it's basically impossible to ask consent from each and every one of the people. So there has been some debate if they should be seen as participants of the study or not. So why this is relevant question is because if you are deviating from the principle of informed consent, you should request a statement from your ethics committee. So if you are not asking direct consent from each and every one of the participants, you should ask for a statement. So in Aalto, our committee has given several statements to this kind of social media studies, but the researcher is always responsible person for deciding on whether you will need to apply the statement or not. But always, if you're unsure of the ethicality of your research or the legal compliance, obviously you can always ask for help and also apply for statement. Many researchers, they like to apply the statement to be on the safe side so that it doesn't create them issues later on, for example, with publishing. But that is definitely the researcher's call to make. And this same principle applies to informing about the research itself as informing about the data collection. So in some cases, if the data is collected from smaller closed groups, which are still in operation, it actually might be appropriate to aim to inform the participants and, for example, publish on the discussion platform a note that, hey, I'm a researcher, I'm doing research here and collecting the discussions for my research purposes. But again, we look at the case-by-case evaluation. We look at the entire setting of the research. What platform? Is it closed? Is it open? Do they have like 10 participants or 1,000 participants in the group? So all these matters are relevant when we're considering like what would be the right approach from the research ethics and from the data privacy perspective. Okay, then we have some useful links and sources for you if you want to learn more about that. actually didn't take as much time as I thought, only half an hour. But yeah, I think now is the time for a discussion and your questions.